You okay? You got it.
All right, my understanding that you was going to file a motion with regards to jurisdiction.
I did.
Okay.
You don't have it?
No, I haven't. I just was stating what we're here for.
Yes.
All right, State, did you receive the defendant's motion to set aside the indictment based upon jurisdiction?
I did, Your Honor.
And have you had a chance to review it?
I have, Your
Are you in agreement?
Honor. No, Your Honor.
All right. Court is calling. Are you ready to proceed on your
Ready?
Court is calling 2024 CR 006-935, State versus John Robeson. Could I have parties announced for the record for the state
Andrew Harris Edelman.
defense?
George Sharman on behalf of the defendant.
And are you Mr. Robeson?
Yes, ma'am.
All right. The defense has filed a motion to set aside the indictment. State, are you prepared to proceed?
Yes, Your Honor.
All right. Defense, it's your motion.
Judge, basically, the line is that one of the enhancements that the state is using is a misdemeanor from Travis County. And the defendant, after he served his probation on it, was granted a pardon in 2004 as to that. And as a consequence, it's not a case, a judgment for purposes of enhancement of punishment because of the pardon. And the case that states that is Cuellar versus State.
Well, have you submitted any evidence to show? that he was pardoned?
There are attached exhibits to the motion. And these were the exhibits that were given to me by the state. And if you look at Exhibit 2, the language in Exhibit 2 says that the case was dismissed. And under 4212 Section 20, back in that period of time, the judge allowed him to withdraw his plea of
But
guilty.
let me ask you this, because I'm reading the order discharging defendant from community supervision. Is that the exhibit you're speaking of?
The one marked, yes, Exhibit
All
2.
right. So what it says in exhibit number 2 at the end, it says that he's released from all penalties and disabilities resulting from the crime of offense, except that proof of said conviction shall be known to the court should the defendant again be convicted of any criminal offense.
He has not yet been committed. He has not been convicted. Not only that, the case is dismissed. It's ordered dismissed. And under the Cuellar case, if you read this, and I'm tendering you a copy.
Oh, did you tender a copy to the?
Yeah, I also gave them notice of that under this section of the Code of Criminal Procedure. So, and this is a copy of the Cuellar case. It talks about it.
All right, State.
Defense counsel would have a good argument if he was right, but he's not, because of the language of 42.12 Section 20. In subsection B, it states this section does not apply to a defendant convicted of an offense under sections 49.04 through 08 Penal Code. Those are the DWI provisions of the Penal Code. So now we have a philosophical problem. If a judge issues an order that the judge lacked the authority to make, has the judge in fact issued an order? And the answer, as far as I can tell, is no. In Ray State ex rel Hilbig, several defendants and real parties in interest were convicted of DWI felonies and were sentenced to regular probation. After completing their probation, Judge Hilbig terminated their sentence, set aside the judgments, and dismissed the indictments. The state argued that the judge had no authority to terminate the probationary periods under Article 42.1 Section 20 at the time. And the Court of Appeals of San Antonio agreed, because the language of the statute means what it says. 49.04 offenses are excluded from the judicial clemency provision. Additionally, in Bradley v. State, which is admittedly not a published report, the Dallas Court of Appeals in 2002 came to the same conclusion on roughly the same facts as this. When a judge issues an order that the judge had no authority to make, we treat it as a nullity. We ignore it, which means judicial clemency was not granted for purposes of this motion to quash, and it should be denied.
Judge, he's referring to the 2015 version of the statute. This, and it wasn't in effect at that time back in 2004 when he was granted the pardon. So what counsel is saying that we can ex post facto apply the 2015 law to my client, which is untrue.
Your Honor, may I briefly respond?
Yes.
I am making reference to Article 42.12 that was in effect June 13th of 2001, which contains this judicial clemency exclusionary language. I'd also like to point out that judicial clemency is distinguishable from pardon, which Mr. Robinson has not received.
All right, so first question, was it a pardon or was it clemency?
It was a pardon. It was dismissed.
Respectfully, Your Honor, if I'm informed correctly, a pardon is something that is issued by the governor. And this order was not issued by the governor. It was issued by the judge of the court to which he was assigned for that case.
It's called
That's
a
not
judicial pardon.
That's not a pardon. That's judicial clemency.
And the Cuellar case resolved it. That's from the Court of Criminal Appeals. Okay, it's out of Bexar County. And they said that in that case, it cannot be used. And this is current with my client's case and the statute as it existed at that time.
All right, State, have you had a chance to review the Cuellar case?
No, Your Honor. However, briefly looking at it, it seems that that covers a felon to possess firearm offense, which has nothing to do with the judicial clemency language in 42.12, section 20, subsection B.
All right, so the state's argument is that your client's offense, past offense, is excluded from not being used in this indictment. He's saying that under chapter 42, that DWI is one of those offenses that are excluded as far as whether or not it can be used for enhancement to provide jurisdiction to the felony court. And you're arguing that's not true?
I'm saying it's not true in this case because the judge allowed him to withdraw his plea and dismiss the case.
Then-
And it works as an acquittal under Cuellar.
Then why does it say, and State, I understand your argument, but then why does the document say that it can be provided as proof
No,
if he's convicted of any criminal offense to the court? If someone is pardoned, then it doesn't come back as proof that you are convicted of an offense.
it doesn't say that it's proof. It's in her order. It just says that the judge could be informed of the existence of the prior judgment. It doesn't say it's proof.
No, it says, and what I'm reading, it says, it is therefore ordered. And then towards the end, it says, he is released from all penalties and disabilities resulting from the crime of the offense, except that proof of said conviction. That's what it says.
Except proof of conviction.
Of said conviction shall be known to the court should the defendant again be convicted of any criminal offense. Now, I understand what the state is saying with regards to chapter 42, but defense, you haven't addressed the issue. The defense is saying that, the state is saying that chapter 42 has been in effect since 2001.
Yes,
The part of the statute, the part of the code that he's reading from. Your client's conviction of this offense was this looks like January 7th, 2022. So wouldn't chapter 42 encompass this, since this conviction occurred after? And
2002,
yes, and the order discharging him from community supervision was signed by a judge in 2004.
or
And the conviction date, it looks like it's 2002. State is saying that code section 42 is from 2001.
that's when I believe that's when it went into effect.
So then if you agree that chapter 42 is from 2001 and that a state is saying that DWIs are not covered by the exhibits that you've submitted to me, then the state would be correct.
Well, it says the language that it uses is that the case was dismissed. And that the judge allowed him to withdraw his plea. So it is no longer a final conviction. So in this instance, the language of the judge caused it not to be a final judgment. And I think under those circumstances, under the Cuellar case, that means that it can't be used for enhancement of punishment in this case. It's not expungible according to the statute, but it can't be used for enhancement. And that's what Cuellar says.
All right, State, are you prepared to address Cuellar? Or do you need more time?
So, Your Honor, as far as I can tell, Cuellar is completely off the mark for this. That was a felon in possession firearm case in which the defendant's prior felony conviction was subject to 42.12 section 28 clemency. And the state argued that essentially 42.021A, 42 points. Sorry, Your Honor, I'm getting confused. 42.12 section 28 clemency should just be ignored so that the state could charge Cuellar with felon in possession firearm. And the Court of Criminal Appeals ruled that no, the state can't just ignore judicial clemency. That has nothing to do with the circumstances of this case in which a person purportedly received judicial clemency that the court by section 20's own terms, he never should have been able to receive because the court had no authority to issue it. And in this circumstance, what this court should do is to ignore that purported judicial clemency order for precisely that reason.
All right, any other argument?
That's all we have.
All right, just give me, if you'll step back, just give me 5 minutes.
Sure.
And I'll review the documents that you've given to the court.